Friends, session number 27 of the series on military law will demonstrate to you that provisions are, have been, are and have been enshrined in the military law to provide a fair and reasonable opportunity to an accused to defend himself. Friends, in session number 27, you would see that court-martial provisions are fair and reasonable opportunities providing to an accused for his defense. Right from the investigation stage, if an accused uh, feels that he has grievances, then he has a right to make a statutory complaint to any officer who deems himself wrong. This right is available to an officer, also persons below officer rank. Parallel provisions where the application be forwarded for redressal of grievances. Insofar an officer is concerned, he may complain to the central government. And this provision would be available to a victim, perhaps if he is a suspect, to an accused or a witness. All of them can make use of this provision if they feel themselves aggrieved or wronged. Also, I'd like to draw your attention to the provisions of Army Rule 180 that are applicable in case of court of inquiry, that any person subject to the Army Act, if his character or military reputation is involved during the stage of investigation, then he has an opportunity to be present throughout, to make a statement, to cross-examine witnesses who are deposing in his opinion against him, to make a statement and to lead evidence. And in this manner, he gets ample opportunity, and there is also a duty cast, an obligation cast upon the presiding officer, that in case a person is there who does not understand such a provision, then it is the duty of the presiding officer to make him known that he has this opportunity or the facility. The person who's affected by a court of inquiry, he can make a statement, can cross-examine witnesses, can produce as witnesses, exhibits, and this is available to him at the stage of court of inquiry. Subsequently, if there is hearing of charge, at the stage of summary of evidence, and even during the court-martial, this right is there to be present and participate effectively in all the proceedings. Aggrieved by the delay in assembly of a court-martial for his trial, or if there is an accused who feels that the provisions of section 80 are not being invoked and it is causing delay, then he can put up an application to his commanding officer under the provisions of Army Rule 27, and it says that in every case where a person subject to the act who is not in active service is in military custody for a period longer than 8 days without a court-martial for his trial having been ordered to assemble, well, he can make an application, and in this manner effectively the delay is cut short, or the agony or inconvenience to an accused is mitigated or minimized. There are also provisions that if an accused is ill, he cannot take part in the proceedings, then an adjournment can be ordered, and this is contained in Army Rule 84, which says that proceedings on death or illness of accused, in the case of death of the accused or such illness as renders it impracticable to continue the trial, the court shall ascertain the fact of the death or illness and may adjourn. So therefore, effectively, the proceedings will not carry on in the absence of an accused. Also, take your mind to the wordings of the oath or affirmation which the members take while sitting on a court-martial. They take oath that they would well and truly try the accused according to the evidence, and they will administer justice according to the Army Act without partiality, favor, or affection. And in this manner, the members of a court are duty bound to lead evidence. Hours of sitting, so that undue burden is not cast on the defense. The provisions Army Rule 81 state that no court shall sit for more than 6 hours in any one day, and this is contained in Army Rule 81, which deals with hours of sitting. The justice should not only be done, it should seem to have been done. And this dictum has been brought into operation in the procedure of Army military law by way of Army Rule 88 provisions, which say that a court martial held under the Act shall be an open court to which the public generally may have access, so far as same can conveniently contain them, which essentially means that as long as there is space to accommodate these members of the public, and however, for the ends of justice, at any one time, the court may decide that a group of persons or a particular person will not have access, so that the proceedings are not unduly hampered. You had already seen in the earlier lecture, previous session, that at various stages the accused has been provided different pleas which he has a right to present at his trial by court martial. Then we come to Army Rule 77, and which says power of court over address of prosecutor and accused. Insofar as an accused is concerned, the court shall allow great latitude to the accused in making his defense. So this is enshrined into the Army rules that in making his defense, he would be allowed great latitude. However, he must abstain from any remarks contemptuous or disrespectful to the court or the persons who are not there. However, he may impeach the motive and evidence of the witnesses and blame them with the cruelty. Well, that is fine. He would not be stopped from that. The responsibilities have been assigned to the presiding officer to see that for trial to be conducted in a proper order in accordance with the Act rules and in a manner befitting a court of justice, and to ensure that justice is administered and that the accused has a fair trial and that he does not suffer any disadvantage or infirmity because of his position as an accused. While the court-martial proceedings are going on, the proceedings are held in the custody of the judge advocate. If there's no judge advocate, then with the presiding officer, and at any stage, the accused as well as the prosecutor can make an application and inspect the proceedings before the court is closed to consider the finding. That means right from start till the stage of finding, the proceedings can be inspected by the accused. Voting. The provisions have been so inserted in Army Rule 87 Clause 2 that voting on any matter, including finding and sentence, starts with the member lowest in rank, so, or seniority. Now, this way, the opinion or the views of a senior do not affect a junior, because the junior already would have given his vote or his opinion in before the court. So the opinion of the members of the court shall be taken in succession, beginning with the member lowest in rank. And Army Rule 87 Clause 2 is applicable in this behalf. Another provision which is provides a meaningful right of defense to an accused is that accused is not required to give a list of his witnesses, and this is indicated in Army Rule 136. However, in case he has not given a list of his witnesses, the responsibility devolves on him to make sure that they are present before the court. Even if something irregular has taken place, the provisions of Army Rule 149 state that the proceedings shall remain valid as long as there has been no injustice to the accused, or he has not been restricted or curtailed in presenting his defense. So any irregularity done will not vitiate uh, the outcome of a trial. But the caveat is there that it should not result in any injustice to the offender. Army Rule 66 lays down that after the court has decided on the sentence, it can give a recommendation of mercy. Well, as the members of the court, they have given the punishment which they deem appropriate, but if they feel that there are strong reasons why the case of the accused should be treated with mercy leniently, then they will give their reasons for recommendation, and this is also indicated in the proceedings. Insofar as the judge advocate is concerned, uh, both the prosecutor and the accused are entitled to seek opinion, advice, comments from the judge advocate on any point relative to the charge when he is in or out of court. Of course, if he is inside the court, they would put up a request to the presiding officer, and with his request, they will seek opinion or advice from the judge advocate. A judge advocate is duty bound under Army Rule 105 to inform the court if there is any informality or irregularity in the proceedings, and more so if it is going to affect the accused. And he shall inform the convening officer and the court of any informality or defect in the charge, and he is expected to give his opinion in the open court. Further, under this rule, the judge advocate has been made responsible to take care that the accused does not suffer any disadvantage or any consequence because he is an accused or because of his ignorance to examine or cross-examine any witness, and this the judge advocate has to ensure he can, with the permission of the court, call any witness and put questions to him which he thinks should have been rightly put by the accused, and he is supposed to maintain an entirely impartial posture. The copy of the proceedings after the proceedings have been promulgated within a reasonable time and free of cost, accused is entitled to receive the proceedings, including after revision, and this is contained in Army Rule 147, which states, which is an elaborate provision pertaining to copy of proceedings, which are under 147 entitled to an accused, and then there is a provision 147 clause A, which says that in certain cases, and which are those cases where the proceedings are not to be given, that is also incorporated under the Army rules. When the trial is over, then an accused gets two opportunities to put up a petition, and these are under Army Act Section 164(1) and 164(2). 164(1) is called pre-confirmation petition. As the name indicates, it is at a stage prior to confirmation, and subsequently, after confirmation, the person can put up separate petition, which is called post-confirmation petition. Only thing is that in this, the accused does not have a right to physically appear. It's a petition which goes, and the competent authority is expected to apply his mind and provide the relief where it is so needed and justified based on the evidence or on the proceedings on record. Also, under 164, clause 1, it is written that competent authority shall take such steps as may be considered necessary to satisfy itself as to the correctness, legality, or propriety of order passed, or to the regularity of any proceedings to which the order relates. So, a suitable correctness can be examined and matter investigated where so needed. And after 164, one stage, when the confirmation has been done, then a post-confirmation petition can be forwarded by the accused to the central government or the chief of army staff or any prescribed officer who is superior to the one who had dealt with pre-confirmation petition and seek a remedy which he considers himself entitled to, and that shall also be examined on merit. There are also provisions under the Army Act section 165 that if this, it is seen that the proceedings disclose illegality or they are unjust, then the competent authority may annul. That means he may set aside the proceedings on this very ground that they disclose an illegality or they show that the proceedings are unjust. In this manner, it would become obvious that military law provisions have been so designed to ensure that the person who is being tried gets a fair and reasonable trial. Thank you.